This is Constitutional Rights in Black and White.
In 1973, the United States experienced a massive energy crisis. Oil prices were skyrocketing. Americans were facing fuel shortages. The Public Service Commission of New York, one of many regulatory agencies in charge of power utilities, concluded that the state was running out of electricity. New York simply did not have enough fuel or sources of supply to continue furnishing all customer demands for electricity in the upcoming winter. And so, to try to conserve energy and keep the price of electricity from rising even farther, the Commission ordered all electric utilities to stop all advertising that, quote, promotes the use of electricity. One of those utilities, Central Hudson, challenged that advertising ban under the First Amendment, claiming that it infringed on its right to have free speech. The case went to the Supreme Court, where Central Hudson argued that the ban was an impermissible restraint on what it had to concede was commercial speech. The Supreme Court reasoned, quote, the First Amendment protects commercial speech from unwarranted governmental regulation. Commercial expression not only serves the economic interest of the speaker, but also assists consumers and furthers the societal interest in the fullest possible dissemination of information, unquote. Wait a minute, said the government of New York. Commercial speech is entirely different from what has traditionally been protected by the First Amendment. In fact, you only extended the First Amendment to commercial speech at all 4 years ago. And now you're deploying this new First Amendment interpretation in a very aggressive way to strike down what we believe is basic economic regulation. It's not that aggressive of an interpretation, was the court's reasoning. Quote, our decisions have recognized the common sense distinction between speech proposing a commercial transaction, which occurs in an area traditionally subject to government regulation, and other varieties of speech. The Constitution accords a lesser protection to commercial speech than to other constitutionally guaranteed expression. In this case, in fact, we're giving less protection to commercial speech than we would if it were, say, political speech. But that's only superficial, argued New York. You're protecting a commercial advertisement at the expense of a very important regulation, serving a very important purpose. The law is trying to conserve energy during a national crisis. It does it directly by stopping the utility from increasing sales through advertising. Oh, we're with you there, said the Supreme Court. In view of our country's dependence on energy resources beyond our control, no one can doubt the importance of energy conservation. Plainly, said the court, the state interest here is substantial. And the state's interest in energy conservation is directly advanced by the order at issue here. But that's not enough. The regulation needs to be tailored. This one is too broad. It's more extensive than necessary to serve the interests that we agreed exists. So it violates the First Amendment. Hold on now, said New York. This is an enormous judicial power grab. You're saying that any court can strike down any regulation of any speech by business, even if the regulation serves a substantial and important public purpose, and even if that interest is actually served by that law. As long as the court, after the fact, can think of a different or narrower way the regulation theoretically could have been crafted. Basically, yes, said the Supreme Court. Central Hudson was an enormously influential case. It created a new doctrinal test that courts still use today in applying the First Amendment to businesses. It opened the door to corporate challenges to a wide array of regulations. It empowered courts to use their discretion to intrusively second-guess legislative and regulatory judgments. As a result, nearly half of all First Amendment legal challenges today benefit businesses and trade groups rather than other kinds of organizations or individuals. This aggressive litigation strategy brought by businesses, in turn, has been costly for the American public. It allows businesses to undermine important and efficient public regulation at the expense of their own shareholders, of consumers, of employees, all in service of what economists call rent seeking, transfers of value rather than increases in value. More broadly, because the new Central Hudson rule is so malleable, it actually destabilizes the rule of law. It makes business law much less predictable, much less general, and much less clear in ways that harm the entire economy. Okay, let's read the case. The 1973 oil crisis created a massive national fuel shortage. Concluding that New York was going to run out of electricity over the winter, the Public Service Commission issued an order barring electrical utilities from advertising in ways that could increase or promote electricity use. Central Hudson, one of those utilities, challenged the order as a restriction on its speech. The first thing to notice is that the court treats the utility's advertisements as, quote, only commercial speech, unquote. And in a concurrence, Justice Stevens would have found that the speech was not purely commercial and therefore entitled to even more protection than the court gave it. But the majority took for granted that the speech was, quote, merely commercial, defining it as, quote, an expression related solely to the economic interest of the speaker and its audience. The challenge was in 1980, and by then the commercial speech doctrine was brand new. Until a few years earlier, the court had rejected the idea that the First Amendment applied at all to commercial speech. Then, in 1976, for the first time since 1776, Virginia Pharmacy Board, a trade association of pharmacists, convinced the Supreme Court to hold that the line between commercial speech, which was unprotected, and non-commercial speech, which was protected, was too simplistic, and that commercial speech also deserved some First Amendment protection. In principle, commercial speech should not get as much protection as traditionally protected speech, such as political speech. The court explained, quote, our decisions have recognized that the common sense distinction between speech proposing a commercial transaction, which occurs in an area that was traditionally subject to government regulation, and other varieties of speech is straightforward and simple. The Constitution therefore accords a lesser protection to commercial speech than to other kinds of constitutionally guaranteed expression. Central Hudson took that idea and tried to articulate how commercial speech was protected, defining the contours of that supposedly lesser protection. At first glance, the doctrinal test might seem unassuming. Speech that is misleading or related to unlawful activity is entirely unprotected. Otherwise, the state must assert a substantial interest to be achieved by the restrictions. This is a standard move in constitutional law. If the state wants to infringe on what is a recognized protected liberty interest, it must justify its interest in doing so. And the regulation must meet additional criteria. It must, quote, directly advance the state interest involved, and it must restrict no more speech than is necessary to advance that interest. That latter requirement is generally referred to as the fit requirement. If a more limited restriction would do just as well, according to this test, the excessive restrictions cannot survive. The Central Hudson fit test represented, however, in practice, an enormous extension of existing doctrine, although the court does not really ever acknowledge this fact. the court asserts that, quote, speech restrictions must be narrowly drawn, citing an earlier case called In Re Primis. But that case involved a nonprofit, public interest law firm, not a business. And the speech there was unavowedly political. There was no dispute about that. It wasn't commercial speech. The court also cites a famous case called First National Bank of Boston versus Bellotti. But that case, too, involved what was clearly political speech, not commercial speech. And finally, the court cited Carey v. Population Services, which involved a ban on advertising or displaying contraceptives. Again, that speech implicated core liberty and First Amendment values. It was not merely a commercial proposal. In other words, the Central Hudson Court engaged in substantial, let us call it creativity, in creating the new fit requirement for commercial speech. It is the way the court then applies this requirement, however, that demonstrates its real power. The court accepts initially that the state interests at stake are, quote, substantial. But the court goes on to meticulously evaluate and second guess the legislative decision and the regulatory rule and why and how exactly the decision to regulate energy advertising in this particular way was carried out. For example, it rejects the idea that the advertising ban would help keep energy rates down, calling the link tenuous, pretending to have knowledge of how markets work that is nowhere demonstrated in the case. It agrees that the ban would, quote, directly advance the state's interest in energy conservation, but it strikes the rule down anyway. The court justifies this by saying, quote, no showing has been made that a more limited restriction on the content of promotional advertising would not adequately serve the state's interest, unquote. And in the same vein, it complains that the commission, the Power Commission, has not demonstrated that its interest in conservation cannot be adequately protected by a more limited regulation. If you think about that, that's a very tough test. It's a very hard thing to demonstrate that all of the possible limited regulations might or might not do just as much as the regulation adopted. The court speculates, for example, that there might be a way to restrict or promote advertising of devices and services that could advance efficiency and enhance conservation, even though the Power Commission specifically found otherwise. And the court begins to spin out other ideas of its own, other kinds of advertising that might promote energy efficiency under a more limited ban. In other words, the court pretty straightforwardly substitutes its own judgment and expertise, or frankly, the lack thereof, for the state agency specifically designed to address those precise issues. In a powerful dissent, conservative Justice Rehnquist, normally someone more aligned with businesses, here complains about this as judicial overreach. He quips that until, quote, I have mastered electrical engineering and marketing, I'm not prepared to contradict, by virtue of my judicial office, those who assume that the ban will be successful, meaning he understands that he would need far more training in the details of what the Regulatory Commission was trying to do before he would feel comfortable second-guessing the agency's decision. One last thing to notice about the majority decision is a somewhat naive view of how American politics works. Laws and regulations are typically the product of compromise. That's the essence of American lawmaking. Agencies and legislatures cannot simply rewrite overnight regulations and statutes to conform to what a court might imagine to be necessary or better or good enough. Rather, imperfectly fitting rules are normal. Imperfectly fitting statutes are a part of the price of political compromise. The Central Hudson fit requirement ignores this reality. The power of inertia will often mean that the decision to strike a rule down will stick. 3 justices who concurred in the judgment, Justices Brennan, Blackmun, and Stevens, did exhibit some doubts about the majority's overall holding. In particular, Brennan and Stevens expressed doubts over whether this particular speech was in fact entirely commercial in the first place. But all 3 of the concurring justices would have given commercial speech, in any event, even more protection than the majority. They objected to the idea of restricting information as a way of manipulating the public in any area, even where the information is entirely commercial, and even when the goal of the advertising is to get people to do things, to buy things, to increase demand, and not really to actually inform them. As Justice Blackmun put it, quote, "If the First Amendment guarantee means anything, it means that absent clear and present danger, government has no power to restrict expression because of the effect its message is likely to have on the public." By contrast, Justice Rehnquist, again, usually a pro-business jurist, thought the state was entirely justified in imposing economic regulations to advance energy conservation in this way. He pointed out that the regulation was aimed at a utility, a business entity, which itself was a state-created monopoly, subject to a comprehensive regulatory scheme. He worried that the court was improperly substituting its own judgment for that of a state in deciding how the regulatory system should be drafted. Justice Rehnquist never liked the commercial speech doctrine. He dissented in the original Virginia Pharmacy Board case as well. But, obviously, his views did not carry the day, and Central Hudson is still with us. The result of Central Hudson was to enable what I think you can fairly call a corporate takeover of the First Amendment. The case provided an open invitation to businesses to ask courts to strike down laws that curtail commercial speech. Those laws will fall, even if they serve concededly substantial and legitimate public purposes, and even if the interests are served in a straightforward and intuitive fashion, and even if the speech in question has no political or ideological content. The Central Hudson fit requirement acts as a kind of blank check, giving judges the discretion to deregulate or preserve regulation as they see fit on behalf of businesses. It is so easy for courts to find a misfit if they want to strike regulation down. It's also easy for them to decide, oh, the fit's pretty good, if they want to preserve regulation. Over time, the doctrine has also radically changed the nature of First Amendment litigation. Empirically, if you look at the Supreme Court cases over the past 50 years, if you look at the Circuit Court cases over the last 50 years, nearly half of all First Amendment challenges are now brought on behalf of or by business corporations engaged in commercial speech, rather than advancing more traditional subjects of First Amendment protection, such as political speech or moral argument, artistic and scientific expression. And when businesses bring cases, half the time they win. They have good lawyers. All in all, those are pretty good odds for the plaintiffs when they sue. Central Hudson was a very good deal for American businesses interested in trying to strike down regulation. More generally, Central Hudson has encouraged businesses to use the First Amendment as a way to avoid regulation altogether, to increase profits in ways that are not obtainable through the normal political process. Economists in general call this rent-seeking, and they do not mean it as a compliment. Rent-seeking refers to inefficient, socially wasteful transfers of wealth from one person to another, typically more powerful person. It permits elite businesses to use legal tools to escape political and legal accountability. It should be pretty straightforward to see how that would be bad for democracy. But what's important to recognize that it's also bad for the free enterprise system, that is, free market capitalism, which functions best when constrained by law. In fact, the market relies heavily on the promise of the rule of law. But Central Hudson has turned law across a wide range of business regulations into something like a lottery. It's reduced the law's predictability, it's impaired property rights, it's increased the part of the economy that's devoted not to productive activity, but to legal gamesmanship. The rule of law, stability, protection of property is essential to the American economy. And so, ironically, the case that's been so good for individual American businesses, allowing them to sue when they see fit to attack regulation, turns out to be very bad for the overall American economy.
My deepest thanks to Professor John Coates. He is the John F. Cogan Jr. Professor of Law and Economics at Harvard Law School, where he also serves as our Deputy Dean and Research Director of the Center on the Legal Profession. Professor Coates served as General Counsel and as Acting Director for the Division of Corporation Finance for the SEC. He's an expert on corporate governance, finance, mergers and acquisitions, and the workings of Wall Street. His most recent book is titled The Problem of 12, When a Few Financial Institutions Control Everything. We're very grateful that he took the time to share his work and expertise with us.